Louisiana enacted the Separate Car Act in 1890. The act held that all railroads operating in the state of Louisiana were required to have equal but separate accommodations for white and black passengers. A group of professionals came together to devise a test, Citizens Committee, to test the constitutionality of the separate car law. They hired their legal counsel, Albion Tourgée. They devised a plan to test the law's applicability by challenging the law's inability to properly and strictly define white and colored. Therefore, they chose Homer Plessy, who identified as 7/8 white and 1/8 African American. Going along with the plan, Plessy purchased a ticket for travel within the state of Louisiana and sat in the accommodations for white passengers. Plessy was asked to move to the car for African American passengers, in which he then refused. He was arrested and charged for violating the Separate Car Act. Plessy's trial in the U.S. District Court was dismissed on the grounds that the act was constitutional. Plessy appealed to the state Supreme Court, in which they affirmed the district court's decision, leading Plessy to then appeal to the U.S. Supreme Court, in which they granted certiorari. That is, a writ or order by which a higher court reviews a decision of a lower court. John H. Ferguson, who is defendant listed on the title of the Supreme Court case, is a criminal court judge in Louisiana, who had initially ruled against Plessy in the Louisiana Supreme Court, hence his name in the title. The attorney for John H. Ferguson was Alexander Porter Morse, attorney for Ferguson. The attorneys for the plaintiff, Homer Plessy, was Samuel Field Phillips and A.W. Tourgée. The Supreme Court took up the question, does the Separate Car Act violate the 14th Amendment? In a 7-1 decision in which Chief Justice Fuller and Associate Justices Field, Gray, Brown, Shears, White, Pickham ruled in favor of Ferguson. And only one justice, Justice John Marshall Harlan, ruled against Ferguson. And one justice, Justice Brewer, who did not participate. The majority held that the Separate Car Act was constitutional as it did not violate the 14th Amendment. The court reasoned that since the act made the separate accommodations equal for both races, it did not violate the 14th Amendment's purpose of ensuring absolute equality for all citizens. Therefore, they ruled that segregation was constitutional as it did not imply racial inferiority of African American citizens, due to accessibility of equal accommodations. This case solidified the constitutionality of segregation in America and adopted the legal doctrine, separate but equal. A part of the opinion authored by Justice Henry Brown reads, "We consider the underlying fallacy of the plaintiff's argument to consist in assumption that the enforced separation of two races stamps a colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it. The argument also assumes that social prejudice may be overcome by legislation, and that equal rights cannot be secured except by an enforced commingling of two races. If the civil and political rights of both races are equal, one cannot be inferior to the other civilly or politically. If one race is inferior to the other socially, the Constitution of the United States cannot put them upon the same plane." With that being said, the only justice to disagree with the majority was Justice John Marshall Harlan, also known as the Great Dissenter, with 123 of his 891 written opinions being dissents. Before being nominated to the Supreme Court by President Rutherford B. Hayes in 1877, Harlan was born on June 1, 1833, in Mercer County, Kentucky. Harlan was a former slaveholder and staunch advocate of the institution of slavery. Harlan was a devoted member of the Whig Party, which was the antecedent party of the modern-day Republican Party. However, after the collapse of the Whig Party in 1854, along came Harlan's political and philosophical ideals. After being defeated and running for United States House of Representatives, Harlan joined the Union Army during the Civil War. He was promoted to the rank of colonel. After resigning his commission, he eventually ran again for public office. It was around this time in which Harlan renounced his former views on slavery and began supporting the Reconstruction Amendment in 1871. He was eventually nominated by President Rutherford B. Hayes to the Supreme Court in 1877. He served on the court for 34 years. Justice Harlan is known mostly for his dissents, mainly concerned with civil rights for minorities. However, Harlan was also an advocate for judicial restraint such that it was not the judiciary's role to interfere in the lawmaking process and favored interpreting the Constitution strictly and narrowly to avoid making decisions based on personal beliefs and preferences. So what did Harlan write in his dissenting opinion, and why is it such a big deal? Firstly, a dissenting opinion is written by Supreme Court justices who disagree with the majority opinion. Justices are not required to write a dissent. However, justices who disagree with the majority decision may write one in hopes that one day their logic will eventually be turned into law, attracting media attention to the case, vindication, and also pushes the majority to addressing more topics in the opinion about the constitutional issue at hand. How did Justice Harlan's dissent do this? Justice Harlan's dissenting opinion argued that the Separate Car Act was unconstitutional. Harlan asserted that the Constitution does not mention race, and his very famous and influential phrase, "The Constitution is colorblind." Therefore, the court's ruling based on race is influenced by racially discriminative personal motives rather than issuing a decision based on precedent, and a strict and narrow interpretation of the Constitution. Harlan goes even further to assert that the holding promotes racial discrimination, as making a ruling that argues different races cannot enjoy the same accommodations may contribute to the existing racial tensions prevalent in post-Civil War America. Quote, "The present decision, it may be apprehended, will not only stimulate aggressions, more or less brutal and irritating, upon the admitted rights of colored citizens, but will encourage the belief that it is possible by means of state enactment to defeat the beneficent purposes which the people of the United States had in view when they adopted the recent amendments." Harlan's choice of words and phrases gives his dissent a very powerful and overtly angry tone, as his disagreement with the majority supersedes his textualist interpretation of the Constitution, and rather is concerned with the injustices inflicted upon the Black community. It is important to note that the majority's opinion reflected the sentiments of the public at the time, and especially celebrated and accepted in the white South. Southern states began to implement segregation laws which required segregation in public accommodations, such as public transportation, water fountains, schools, bathrooms, just about anything, arguing that as long as accommodations were made equal, it was constitutional. These are just a few examples of what was considered, quote, separate but equal. Therefore, this decision led to outrage, disappointment, and a great deal of protest among the Black community. Despite abolishing slavery, which led to the Reconstruction era, which during this time affirmed 3 constitutional amendments and a multitude of laws, which were directed to addressing the racially discriminatory effects which the institution of slavery contributed to. Therefore, Plessy v. Ferguson's decision reaffirmed to the Black community that America did not see them as equal. Quote, Black citizens who saw it as a further step toward the total repudiation of 3 constitutional amendments. However, the Black community fought and protested. As discussed prior, Justice Harlan was not writing his dissent with the public majority as his intended audience. So then who was it? I argue it is the Black community. This quote is taken from Peter Canello, the author of a biography of John Marshall Harlan's called The Great Dissenter. Quote, his dissent was largely invisible in the white community, but it was read aloud in the Black churches, it was published in Black newspapers. This was the one link of hope that white people might support them and see law through their eyes. Harlan Marshall equipped the Black community with the confidence that there was a judicial path outlined by the dissenting opinion, which could overturn the case which made racial segregation constitutional. Thurgood Marshall, one of the leading Black attorneys and eventually the first Black Supreme Court justice, followed the judicial path outlined by Harlan, as he quoted Harlan in all the briefs in overturning segregation in Brown v. Board of Education. Prior to the Brown case, Marshall was known to read aloud Harlan's dissent and fixated on the memorable quote, "Our Constitution is colorblind." The quote's appearance did not stop in the briefs or in the discussion, but appeared in oral arguments in front of the Supreme Court. As Thurgood Marshall argued, the Constitution is colorblind and neither knows or tolerates classes among citizens. So why are dissents important, and why should you pay attention to dissents? To conclude, dissents not only serve as blueprints for addressing constitutional issues, by offering alternative interpretations of the Constitution, laws, and precedents, but also speak to the minority to inspire advocacy and address inequalities and inconsistencies of the legal system.